So, Edward, we're ready to go?
Yep.
All right, day 3, my lovelies, of our Facebook Live. Okay, so you know how law is a very famous and popular subject in TVs and movies. We have courtroom dramas and Law and Order and corporate and Wall Street intrigue. You would probably think my area of law, estate planning and estate settlement, is kind of dull, boring, dusting out to pasture. Well, I'm here to tell you the opposite of truth. This is an exciting area of law, and I have some fascinating cases. So, case in point, recently I settled a case. I had a case in my estate administration, which I find really, really interesting, and I hope you will too. So, I had a client who was ill. She was not mobile, but she had her wits about her, and she called me to her bedside to do her last will and testament. And she told me that she wanted to leave her substantial estate to her caregiver. Her children were deceased. She had one grandson who rarely visited her. He grumbled when he did. He didn't want to take care of her and threatened her with a nursing home. She had found a caregiver who was prepared to give her 24-hour care. She was really, really kind. She was prepared to be there 24 hours, cook her homemade food, and promised her that she would keep her in her home all the way through the end of her life, which they knew was coming to an end. So I told my client that the law looks with heightened scrutiny upon estates left to caregiver. My client said the caregiver had treated her like a mother, she was like a daughter to her, and this is what she wanted. So the estate was left to her caregiver. Months passed, true to her word, the caregiver did everything she could to keep my client in her home, keep her comfortable, keep her happy until her death. So after my client's death, we began to administer the estate. Within weeks, sure as eggs, a 3-inch thick lawsuit plopped on the mat. It was the grandson accusing my client of undue influencing and demanding that the entire estate be turned over to him. Well, this is, as Charles Cosley says, where the law is as tricky as a 10-foot snake. Normally, when you file a lawsuit, you, the plaintiff, have the burden of proof against the defendant that you filed the lawsuit. Depending on what kind of lawsuit it is, it can be a different burden of proof, but it's almost always on the plaintiff. However, in a caregiver case, the law turns on its head. The burden of proof is on the defendant to prove that they did not do what they're accused of. So it was on the caregiver to prove that she had not exercised undue influence to be left the estate. So while the facts I knew were on the caregiver's side, the law was very much on the family side. So I brokered a settlement where both the caregiver and the family received a share of the estate, hence preventing years in court and saving hundreds of thousands of dollars in costs. Was it a fair result? I'll leave that up to you to decide. And I'll see you again tomorrow when I'll share another of what I believe are fascinating cases from estate planning and estate administration. Enjoy your weekend. Thanks. And